Okay, now we are started conversation with consultants. Okay, now we are started conversation with consultants, episode 31. So introduce yourself first.
Yeah. I'm audible.
Yeah.
So my name is Sowmya Parsuraman. I'm a practicing company secretary and an intellectual property rights attorney and trademark agent, and also an insolvency professional from Chennai. My firm's name is Sowmya and Associates.
Okay. The only things that stand between you and your dream is the will to try and the belief that is actually possible. It is a beautiful quote quoted by Joy Brown. So with this quote, I would like to bring our talk show name Conversation with Consultants with episode 31 of our guest talk series. Good evening everyone. I am Rima Kumari, a HR associate and ECR coordinator of SKNG. Okay.
Puja Kumari, coordinator of SK Associates and Group, and we both are your hosts for today's talk show. Before we ISO certified management consulting firm registered under the MSMED Act 2006 with the Government of India. Our mission is to provide consulting services to student entrepreneurs globally, covering areas such as compliance, operation, marketing, research and development, human capital, strategy and operations. Our passion lies in helping deep budding entrepreneurs bring their dreams to life and contribute to global economic growth.
Okay. Entrepreneurship is a catalyst for change and innovation. It's a powerful force that can be reshape industries, transforms lives, and make the world a better place. We are committed to supporting student entrepreneurs on their journey, equipping them and with the tools, knowledge, and networks they need to succeed. Am I audible?
Yeah. You're audible.
Now, before we begin our show, let's take a moment to introduce our guest for today. It gives us immense pleasure to welcome CS Sowmya Parsuraman, a practicing company secretary and trademark attorney from Madras chapter of SIRC of ICSI to this special event. We are truly honored by your presence today and we are thrilled to have you share this with our first question for you. Uh,
Yeah,
am I
I just
audible?
want to clear one thing. I am a practicing independent practitioner. So I don't have any tie-ups or anything from with the SIRC or any of the chapters of ICSI. Okay. So I just want this to be taken on record. Yeah. Please. Sorry for the interruption. Please carry on.
Okay. Now let's start. Can you explain the role of a trademark attorney and how it differs from other intellectual property law practices?
Trademark attorney. The role of trademark attorney is, please, the question.
Can you explain the role of a trademark attorney and how it differs from other intellectual property law practices?
See, all said and done, intellectual property rights has different branches, be it trademark, be it patent, be it copyrights. So, more or less, they are all branches of intellectual properties. Only difference when you talk about trademark is that the trademark is dependent on what is your image or reputation in the market. So that is what is being protected. So we have to see what is the subject matter which is being protected. In trademark, it is your name, reputation, or image in the market that you have created after a lot of that is incurring a lot of expenditure, taking lot many efforts all these years down the lane. That is getting protected. In copyright, it is your original work, whatever be it your any kind of written work, textual work, literature or music or any artistic work, whatever it is, the original work that is getting protected. In patent, it is some kind of innovation, invention, which is getting protected. So similarly, the same thing when you say an attorney can be for anything. It can be for trademark registrations. It can be for copyright. It can be for patent or whatever it is, depending upon what you call what is the subject matter that you are trying to protect. So a person who deals in registration of trademarks can be called a trademark attorney in general sense. So it can be for registration, it can be for renewal of application, that is applications, that is the applications which are already registered, it can be for anything. But the person is going to represent the particular client for trademark purposes. That's what it means. Yes.
Okay. Your next question is, what are the primary steps involved in registering a trademark?
Stages.
What are the primary steps involved in a registering a trademark?
See, first is that you have to understand when you are registering a trademark, there can be two categories. Is it a mark which is going to be used in future, or is it a mark which is already in use? Then the process are slightly different. If it is something which is going to be used in future, then it is like only you're making an application and waiting for the clearance from the examiner. And if there are any queries raised or any corrections or changes or modifications are required to be done, you do that. You reply if there are any conflicting marks, and you get an examination report when it says that these are the conflicting marks, then you have to reply to that, so on and so forth. And if it is something, a mark which has already been used, then you have to give the proof of usage. Okay, so suppose if I have been using my mark for last 10 years, so I have to substantiate my application and statement saying that, okay, this is the proof, how I establish or substantiate my statement that I have been using the trademark for last 5 or 10 years. Say for instance, invoices, which includes details of the mark which has been used. And before all this, one of the most important aspects where consulting comes in is when a client wants a mark to be registered. So it becomes imperative to find out whether there is already any such similar or conflicting mark which is being used in the same trade or same activity. So this has to be ensured by undertaking a search on the trademark registry portal by seeing what are the marks which have been already there. And by that is that is entirely that is a technical area wherein you type the word or logo or similar whatever it is, their design or whatever it is, and see whether there is anything similar to this. Because ultimately the purpose of getting registered is to avoid confusion. See, when you say that a particular trademark belongs to you, the consumer understands or relates or links the products which has your trademark with the origin of the product, from where it is coming, who is the manufacturer, who is the promoter, or who is the person behind this. So if it is likely to cause a confusion over here, say for Mr. A has also applied for the same mark and B is also applying for the similar mark, and if there is a confusion, the consumer will be at a loss to understand from whom it is coming. Is it A or is it B? So it is always advisable to undertake the search first to see. And then once you are say for instance you confirm it that okay, there are no conflicting marks, it's safe to make an application, you are making an application. And once that is done, the preliminary checking is done, and if there are any technical defects, then again what do you call the query or this thing is sent to you, and if any corrections or modifications is required, you have to do that. And then again the mark is then processed by the examiner to see if there are any conflicting marks. And we have to understand that basically the way we look at a mark and the way a consumer will look at it and the way the registry looks at it can be three different things. Okay, so while the applicant is making an application, he may say that okay, my mark is different, but the consumer may not be able to differentiate. If it is confusingly similar to some other mark, the consumer may not be able to differentiate it, and that thereby it can cause a confusion, and he might start buying your goods thinking that it is actually coming from some other origin, from some other person, or the reverse can also happen. So if that is the case, in such cases, the registry will take that into first consideration, and it will ask you why you have done this, or this cannot be proceeded with because these are the similar marks that we find are similar, can cause a confusion. So therein you have to give a reply saying that either you have to see whether if you have not done your search properly, then again it comes to back to square one. If that is not the case, then you have to explain how you see it different. Say, for instance, it may be a picture of a leaf, but say, for instance, you have a picture of a leaf, which actually a collection of leaves which depicts, say, Ganeshji. Okay, so somebody can read it as only a leaf. Then you have to explain this is not simply a leaf. This depicts something else as well. So you are giving your explanation, whichever way. So now you give your explanation. If the registry is satisfied, then it goes to the what do you call next stage. When you say it's a next stage, then that is the registry approves it, it publishes it, and the basic so the basic purpose of publishing is to invite representations from other people who want to establish that there is a conflicting mark, or the mark which is under application, that is the mark that you have applied, is similar or deceptively apparently similar to their mark. Okay, so if that comes into the picture, and whenever that is notified to the examiner, that what you call whatever representation is made, that will be shared with you, and you again have to see to it how to reply to it, whether they are actually similar or it is the same, or they are entirely different. What is it that you want to say on it? So then once this opposition gets clear, then it is again accepted and put forth, and the mark gets registered. If it is not getting clear, then again we have to see other aspects of it. It might get refused, then you'll have to see and to try to make another application, or the applicant has to accept the fact that it is deceptively similar to someone else's mark, and so on and so forth. So this is the basic process. Yes.
It's a good sound.
Okay, moving ahead, next question. How important is to conduct a trademark search before filing for registration?
How important is?
How important is it to conduct a trademark search before filing for registration?
See, I believe in conducting a exhaustive search. Okay, it depends upon the people who are handling it. At times, what happens is that people sometimes it so happens they will simply make an application. As soon as an acknowledgement is made available, that acknowledgement is given to the client saying that okay, you are being registered. It does not work like that. Usually, it takes around anywhere 1.5 years to 2 years to get a mark registered. Okay, so it's not a small duration that is going into this process. So my personal view on it is that as soon as somebody or a client comes to me and says that we want to register this mark, I make it imperative that there is an exhaustive search being done and see whether there are any conflicting marks. Even if there is a very remote possibility of confusion, then also a report also can be generated depending upon what are the similar marks or depending upon what search you are doing, along with the classification, that is the class under which it is classified, that the activity is getting classified. So I make sure that none of the elements of conflict are there. Now the reason for this is that once an application is made, the applicant is also waiting for to get it registered, and also he is spending on it. He is taking efforts to in marketing and everything, and afterwards if it gets refused, then there's no point in trying it after putting so much of effort. See, if I have an, let us look at it this way. That is, I have a mark which says ABC, reads ABC. Okay. Now, if whatever efforts I am going to take, whatever marketing or expenditure that I am going to take, it will be the same whether it is ABC or PQR. In both the places, the effort is required. But if that particular ABC is deceptively similar to some other mark, so and ultimately after completing all this, and it does not get approved, and or tomorrow it gets into litigation, what is the point in spending so much of effort into it? It is if you see from the point of view of the applicant, he's like spent so much of money on it. He has taken so much of effort. Everything going into bin, that is dustbin. So what I think is that if there are any conflicting, there is a possibility of a conflict. I go back to the applicant and tell him, see, these are the aspects. Anyhow, you are going to make efforts. Why not make certain small changes so that your mark attains that or acquires that distinctiveness? It has a separate standing or be it appearance or be it a phonetic effect, whatever it is. Distinctiveness in the market. It is for your own benefit. It adds to your own reputation and image building. So I think that is the most important aspect of the process. That is for making application. That is conducting a very good search. That is very, very important aspect, which cannot and should not be avoided or made away with. Yes.
Okay, your next question is, what are the common mistakes business make when selecting a trademark?
Mistakes in selecting trademarks, is it? Right? Okay. Now, the mistakes can be intentional, okay, or it can even be unintentional, or sheerly because of negligence. There can be many categories. So you come across all kinds of people in this world. Now, there are people who try to imitate some well-established marks and try to sell or move their products or services, whatever it is, goods or services, whatever it is, in the name of that particular mark. They think that since this particular mark already has a well-established name, I can encash that particular image for myself and gain out of it. So in the long run, it does not work well, because anyhow you are going to take efforts, anyhow you are going to spend money, anyhow you have to develop your business. There is no going back on that. Okay, when you are using someone else's well-known mark, say for instance you are using the name of Reliance, okay, and you are selling your products in the name of Reliance. In the beginning, Reliance will keep quiet because you are only a struggler. But as soon as you start selling your products very well and you start achieving good results, Reliance will step in and say that you have been selling the products in his name, and so the revenue and everything is something that has actually come to Reliance, and it will take legal action against you. So you're losing everything, right? So the best aspect, best way of doing things is that don't do this. Right from the beginning, be clear and be put in efforts for your own brand. Don't copy or imitate someone else's brand. Now, this is where the case is intentional. Okay. Now, there can be unintentional cases where you are either you are yourself making an application, you are not hiring a professional, or the professional or the consultant who is working for you, whom you have hired, is not doing a proper service. In such cases, it may so happen, as we have already seen, the search has not been done properly and you are making an application. And even when the application is pending, you are using the mark and everything is happening, and tomorrow it doesn't get approved. Either the examiner, that is the registry itself, refuses it, or there is somebody opposing it, and later on the issue gets settled then and there. Or even after getting registration also, people can definitely say that this is my priority, it is before that, and this person is using it. So I would say that it is always it is very very important and imperative that you be careful what is it that you are selecting, how it is you are selecting, is there. And what I suggest usually is that relying only on the registered marks is one thing, but apart from that, also see if you are in a particular industry. Say for instance you are in the software industry. Now, the client, the consultant or the professional who is helping you, he may not be aware who all are the other players, but you will know who are your competitors, who are the other players in the market. So ensure that your mark is not even that is remotely similar to any of those people. Because if you try to touch that area, the market share that they are having, they are not going to keep quiet. So what are you gaining by getting into what you call unwanted litigation? Only the advocates and lawyers get benefit out of it. Definitely not the parties. So I would say that it is very very important when you select a trademark that they are entirely distinct. They are in nowhere similar, even remotely similar. Leave apart identical. I won't even say identical. Even remotely similar to any of the big names. Yes.
Okay. Moving ahead, next question. How do international trademark law affect businesses operating in multiple countries?
How do? Please, I don't get it.
How do international trademark laws
Hmm.
affect businesses operating in multiple countries?
Yeah, they do. They have a very big impact. See, when you are within India, see, there are two categories of marks, which is one is national, that is marks at the national level, and the other is at the international level. Okay, when we are talking about the Indian domestic market, we are talking about the Indian market. That is, you are registering your mark at the Indian registry. But if you want to sell it, you are selling your products outside India also. There also the same kind of things can happen. That is the usage of your brand, or somebody is copying you, somebody is selling in your name. All these which can happen within your territory. There is a jurisdiction of your own country. Can also happen similarly, or even at a wider base, or serious. With serious consequences at the international level also. So what is required is that if you are planning to sell or already selling your products in some other jurisdiction, some other country also, it is advisable that you get your mark registered in that country as well. Now, what we have to understand over here is that every mark or every law, that is, the law is different, the law of one country is different from another country. they are not the same everywhere. Okay, what Indian law says may not be the same that UK law says or US law says. They have their own set of laws. They are not going to follow your laws. So if you want to enter that territory, you are bound by their laws. Okay, so depending upon which country it is. Now there can be many countries, and every country has its own what do you call contentions and ideas of law and judiciary and all those things. So if you are entering into a foreign market, you have to get yourself registered in that particular country as well for your trademark. Now that is a provision. See, there are two ways of doing it. Either you get yourself registered directly in that particular country. Okay, say for instance, I won't name any of the countries because I don't want to create any confusions over there. Say country ABC. Okay, now this ABC countries, now we have to check whether this ABC country allows their foreigner to register his mark. Okay, because so far as that country is concerned, you are a foreigner over there. Some countries allow foreigners to have their marks registered in their country. Some countries say that they will allow only if you have a local office and commercial establishment there. Otherwise, they won't allow you. Then there are countries which what you call allow it or permit it only for their own citizens. They won't allow you at all. Now there are countries which don't even entertain applications in English language. So you have to see which is that country where you are trying to which that is the market which you are trying to access. What are the laws which are applicable to that particular target market? So your decision will be based on that. Now, there are countries who are members to different conventions, that is, international conventions. Not all countries are members to all conventions that we have to accept. Okay, so if the country is a member of the any of the conventions and it is that is through WIPO, there is a what do you call possibility of getting yourself registered, then the first thing that you have to do is you have to first get yourself registered or at least apply in India, and based on that application you can through WIPO you can process or apply for a trademark in the target company as well. Target country as well, depending upon which country it is, depending upon what is the market that you are trying to access. Now, this has its own process. First, it has to get clearance from your local trademark registry. Then it goes to WIPO. WIPO does its own checking and everything. It clears it over there, and you have to pay the fees in Swiss francs. And then it will again forward it to the particular country, the destination country, wherever you want to get your mark registered. They will also do the checking and everything, whatever is required, and they will and the same process is followed. Say, for instance, if you are taking USPTO. Now, the process of approval in USPTO is similar to that of that we have in India. They also have their examiners checking your application, whether there are any conflicting marks, and if any what do you call details or description something is missing, then they will ask you to correct it. The way we have examiners examination report in India, similar you have something comparable which happens in USPTO. Then you have to make the applications and make the corrections or send replies and everything. And you at times may require an attorney also who is practicing there. Okay, so now if I am an attorney in India, doesn't mean that I am entitled to practice throughout the world. If had that been the case, things would have been far simpler. But it does not work that way. That attorney who is practicing over there, he is practicing under the legal setup and the law of the land, that is, which is applicable to the United States of America. So he will practice over there. He will that is represent your case, that is your applicant's case over there, if it is required, not always, if it is required, and then accordingly they will follow their own due process and register your mark. So your mark will have two registrations, effective registration. One is with the Indian registry, and another will be an international mark, but in the USPTO, that is in the United States of America. But if you want the same mark to be registered in, say, European Union, or say Germany, or say Japan, separate applications have to be made. Okay, it's because each and every country has its own set of laws. So you should be fitting into their own framework, their own individual framework. Then only they will allow you to have a mark over there. If you are not fitting into that, they won't allow you. Now, this can be what are their prerequisites, what is their eligibility criteria can change from one country to another. So, this is one aspect which we have to take into consideration while you are going for international marks. Yes, I hope it is clear, but without knowing the country, it's difficult to explain. You need to know the facts. Yes.
Moving ahead, your next question is: can a trademark be registered if it's similar to the existing ones? What factors are considered?
Can a trademark? I don't get it.
Can a trademark be registered if it's similar to the existing one? What factors are considered?
No, it cannot be registered if it is similar to another. It cannot be, because it will definitely cause a confusion. So it cannot be registered. If you try to register, it will not be registered. The registry itself will not allow it. Leave apart other things. If it is similar to a registered mark or which is already registered and on records of the registry, it will not get registered. That is why I am saying in the beginning itself, search is very important, because if it is already similar to some existing mark, unnecessarily you are taking efforts to market it, unnecessarily you are trying to access the market and create a market share for you. So be it ABC, be the name ABC or be it PQR, you are going to take the efforts. The activity is the same. So why run after ABC alone? If you in the beginning itself you are discovering that it is not allowable, you are going to have roadblocks. Better go for PQR. No, make some changes, relevant changes, which allows you to have some kind of distinctiveness. Why unnecessarily invest and work upon something which is bound to fail when it is pretty clear that it is not going to work? Yes.
Okay. How do you handle cases where a trademark is challenged on the grounds of the being generic or descriptive?
Generic or
Descriptive.
see there when you make an application, the objection that comes from the registry can have two grounds. Okay, either it is under the legal terms, it is either under section 7 or under section 11. Okay, when you talk about section 7, it is absolute ground wherein the registry usually never ever allows that, and I don't even support the idea of making an application in such a way that there is a possibility that you may counter there is problems under section 7. Okay, it's better that you go for something which is, now I will tell you what is generic. Now, when you come, there is talk about what is generic. Now, say for instance, I am dealing in textiles. Okay. Now, if I say that my trademark is clothing, I will not get the registration. I cannot register in that name. The reason is that there are so many people who are in clothing. Okay. Or I say that woman, I am having a boutique, or I'm a designer, and I want to register my mark as the name of woman, in the name of woman. I am not the only woman, there are so many women. Where is the distinctiveness? How can I block the name woman? If I put Sowmya, possibly, then again we'll have to see whether there are conflicting marks. But woman is a generic word. So this is how it is viewed by the registry, whether the name is generic in nature or different. Distinctiveness is something when I say Soumya's clothing, Soumya's boutique, or that is okay. That is understandable. Now there can be a number of Soumyas also. Then that will come under conflict. If there are conflicting marks, then again we will have to that will come under section 11. But if that is going to be in the name of woman, anybody is a woman. I'm not the only person who is woman, right? So in most of the cases, I don't advise anyone to make applications in such a way that the mark can get issues or can have problems or can be considered as a generic mark. It is not advisable at all. It is not only at the registry level, even after the applicant starts using it, that can also, at that stage also, it can cause problems. So it's always better to avoid generic names. Yes.
Your next question is, what are the common reasons trademark are rejected by authorities?
Common grounds on which trademarks are rejected, is it? Yeah, if
By
it is,
authorities.
yeah, if it is like, say for instance, first one is you are a generic. If it is a generic name, if I say I want to reserve the name woman in my name because I am a woman. Nobody is disputing that you are a woman. But you are not the only one, right? There are so many people who are who fall into that category. That is one aspect. Second is conflicting marks. If you are deceptively similar to your mark is deceptively similar to someone else's mark. Now, see here there are many issues. What is deceptively similar? Now, here we have to understand it is always better to play safe. Okay, so even avoid the remote possibility of confusions. Now, the thing is that the many a times what happens is that the registry may give a clearance to your application. Okay, but when it is published, people others who are noticing and they don't want you to enter into the market, they can what do you call apply for an opposition even when it is your mark is not entirely like their mark. Okay, now here what happens is that what we have to understand, we have to see things from the practical perspective. Whom are you? Who is that person on the other side? If that person is a very big player, your case may be a genuine case. Now, this is the practical aspect I am telling you. Theoretically, you can go on fighting with litigations. You can, as we know, judiciary allows you to, for innumerable years, the litigations and disputes can go on. Now, it can get shifted from one authority to another. Be it the first it will be at the tribunal, then it will be if it gets registered. Even if it gets registered somehow, the tribunal tribunal passes an order outside. Also, it can be challenged. There are so many ways to stop you from prospering. Now, if that particular, assuming the other player who is opposing your application is a very big player, he anyhow is going to be well equipped as compared to you. Now, the question is, are you interested in running a litigation for years together, spending money on it, or you want to simply change your mark? Okay, you have applied, there is going to be a conflict. You can see the intentions of the people. Okay, withdraw it or leave it as it is, abandon it and make a new application. Ultimately, what is your purpose? Your purpose is to run the business, right? Your purpose or intention is not getting into litigation and spending money on it. More so if you are a startup, you don't have money to survive. Okay, so you are inviting investors to help you with the capital inflow, and whatever is coming in, if you are spending it on litigation unnecessarily, who is getting benefit out of it? So all these things are on, that is based on case to case basis, depends upon the facts of the case. You have to see what it is. what it is you are going to register, who is the other player, can there be a remote possibility of conflicting marks, all these things have to be taken care of. And this is where the role of a consultant comes in, because the consultant can do the job for you. He can look into it, who is that player, why is he taking taking a stand that he will not allow you to enter, or possibly he is seeing you as a very strong competitor in future. That can be why people are doing things. They can have their own agenda. We never know, and there's no need to know as such. As long as you know what is that, you have clarity what is what and what is that you want to do, you need not worry about who is doing what. When you know, okay, here there is going to be a roadblock, he is not going to allow you to survive, you simply change your methodology. If plan A does not work, go and see whether plan B works. There are 26 letters, there can be one of them definitely is going to work for you. If not A, if not B, if not C, D, E, something will work for you. So I won't advise that it is a very good decision. Even if there is a roadblock, I'm going to get into a litigation, I'm going to contest it. There is no point. That is not the purpose of your existence. Your purpose in business is to earn a revenue, to create a reputation for yourself in the market. That is the basic purpose of your existence. What is the point? And he might spend more money on it. So obviously, he's going to be what do you call, well defended. Possibly that may not be possible for you. And that money, that outlay which you have already spent, or even spending on small lawyers for that matter, that is also an excess expenditure for you, right? Why get into it? Better to keep things simple and uncomplicated. Yes.
Okay, moving ahead, we would like to express our sincere gratitude to for being our guest for today at Conversation with Consultants. Your presence and engagement helped to make it a success. Thank you for providing insight into your inspirational journey. Further, we would also like to CS Sowmya Parsuraman, practicing CS and IPR Attorney Sowmya and Associates. Thank you, Sowmya.
Thank you. Thank you so much, madam. Thanks a lot for providing me an opportunity. Thanks a lot.
Further, we could also like Further, we could also like to thank our audience for listening patiently throughout the event. And thank you for everyone for joining with us today, and hope to that everyone has gained some knowledge from this event. Looking ahead, we are excited to announce that our next episode 32 of Conversation with Consultants will be held next weekend with Professor B.C. Anand, Assistant